allowed to question Ms. Flores about any testimony she's given here today. I'll then move on to the claimant, and Mr. Alamo, I'll ask you some questions. They'll be similar to those that were asked of the employer. After that, if your attorney has any questions for you, she can ask those. Then Ms. Scales will be allowed to question you about any testimony you've given here today. That will conclude the hearing. My decision will be prepared today, mailed tomorrow. Both parties should have a copy of that within about a week. Are there any questions about what I just explained, Ms. DeBell?
There's no question, Judge, thank you, but I do want to ask you if now is the appropriate time for me to object on my client's behalf to the appeal of this hearing.
There's no choice in the matter, ma'am. There's no room for objection. This was a remand by the Board of Review.
What I mean by that, Judge, is that we received no documentation, which I assume was submitted to the Board of Review. And so just for the record, I'd like to object that we received no documentation as to why the employer could not appear in December.
Well, you wouldn't, and it doesn't matter. The Board's issue on that, or ruling on that, is final, Ms. DeBell.
No, I understand that, Judge. I understand that.
I guess I'm not sure what you're objecting to. You would never be given the documents that the employer presented to the Board. Is that what you're referring to?
I am. I always understood, Judge, if something was submitted to the Board, that it had to be submitted to the other party.
No, ma'am, that's not the case. Not when it comes to an appeal.
Okay. I always do that when I appeal, Judge, so I always assumed that was required.
If you're relying on documentation as part of your evidence or some other thing, but not the request for a hearing in this case where the employer did not appear in the first hearing is not something that needs to also be provided to the other party. Now, documents are a different story.
Okay, except that the Board of Review did refer to something, but I guess what you're saying, Judge, is what the Board of Review referred to was the same as what you had in your decision, it sounds like.
No, all they're saying is that this is their decision. We find the employer did have good cause for being absent from the scheduled hearing. The absence was brought about by reasons outside the employer's control and through circumstances that could not have been foreseen or avoided. We remand to the referee with instructions to schedule hearings for the purpose of obtaining such evidence, blah, 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 blah.
Okay. Then the second thing, Judge, would be, as you know, of course, I submitted documents in time for the December hearing, and I would ask those be admitted into the record, I should say.
No, I can't do that, Ms. DeBell. I don't do anything with documents unless there is a reason to admit them, and there wasn't. So every hearing is separate and distinct.
The Board of Review decision, Judge, stated that anything that had been submitted...
Where does it say that? I don't see that. It says nothing of the kind.
I'm sorry, I'm going to the Board of Review decision.
It says evidence for any prior hearing. There was no prior hearing.
Judge, this is a problem.
No?
We remand this matter to the referee with instructions to schedule the hearing. Evidence from any prior hearing in this matter shall be incorporated.
But there was no prior hearing. The case was dismissed because the employer did not appear. If there's no hearing, there can be no evidence admitted into the hearing.
I understand. I understand that now, Judge. Then, given that, we would like to request a new date for hearing. This is my mistake.
No, we'll go ahead with it. Necessary, you can use that as a basis on your appeal, but we're going ahead with it. I'll just tell you, folks, rarely does it come down to documents. That's why we have parties here. We've got live testimony and the right of cross-exam. So let's move forward. Noting your objection, Mr. Bell, we are moving forward. Any questions, Ms. Scales?
No, sir.
Let's get started. Ms. Flores, did Mr. Alamo work for City of Chicago Fire Department?
Yes.
When did he start there? Was it February 1st, 2016?
No, 2006.
Okay, and he worked for the employer till when? August 8, 2017?
Yes, August 8, 2017.
Was he a firefighter?
Yes.
Okay. How did his job end, Ms. Flores? Was he discharged? Did he quit, or was he laid off?
He was discharged.
And was he given a reason for his dismissal?
Yes.
And what was that?
He exhausted all available time, his available sick time.
Well, had he been released to work?
No.
Okay. So you're aware that he was not released to work. He was still under some type of medical disability, but because he was out of available leave time, whether it be FMLA, medical, or other, he was released?
Right.
Yep.
He was not released. Yes. He was out of time.
Well, I mean, he was released from his employment. He was separated.
Oh, yes, yes.
Okay. Why isn't this a Section 601B1? Any objection to that, Ms. Scales?
I don't know if this was supposed to be a Section 601B1.
Well, I don't care. I don't care what the local office said. Sometimes there are numbskulls. Your witness, and the one you're relying on, just told me that he was separated because he couldn't return to work for a medical issue because his time ran out under any type of leave that was available, and he's still not medically released to go back to work. If that doesn't...
That is a fact, sir.
Of a Section 601B1, I don't know what is.
That's fine, sir.
Okay. Mr. Bell, any objection?
Well, the only objection, Judge, is that this...
How can you possibly object to your client getting benefits and the employer not being charged?
All right, Judge, I don't object.
Okay, I'm just telling you, that's how it works, Mr. Bell. It'd be a voluntary leave. The voluntary leave reason is because he had not been released to work by his doctor. The employer was aware of that. He was out of time. There was no time left to give him, so he was discharged by the employer. But in our case, we call it a voluntary leave. He's eligible for unemployment benefits, and the employer is not charged. Do you have any questions about that, Miss? I haven't gotten this note, but I don't see where there'd be a problem. But if you have a question, I'll be happy to answer it.
My client has a question, Judge. May he ask?
Sure.
Judge, I was released by my medical doctor, by my physician, on July 14, 2016. And I also gave that letter to the medical section, and I also on June...
Okay, then, folks, we don't have a Section 601B1 because the claimant's got contrary information. So we're going to go ahead with the hearing. So, Ms. Flores, your testimony is that he was discharged on August 8th because he ran out of time and had not been released by his doctor. Is that correct?
By Chicago Fire Department physician.
Okay. And is that the operative factor?
Yes.
Okay, let's move on then. Any questions for your witness, Ms. Scales?
Actually, no.
Okay, and Ms. DeBell, any questions, Ms. Flores?
Yes, Ms. Flores. So you're saying that the doctor that the medical division of the fire department uses did not release Mr. Alamo to work. Is that correct?
Yes.
Okay. So do you also have information as to the psychologist that my client saw, a Dr. McLaughlin? Do you have information as to what his opinion was?
No.
You do not have that information?
No.
Are you aware that Dr. McLaughlin released my client to return to work?
No.
All right, Judge, I will have testimony from my client to these facts.
All right. Move on then. Mr. Alamo, did you work for the fire department?
Yes, sir.
Start there in February 2006?
I'm sorry, sir?
Did you start there in February of 2006?
Correct, sir.
And work there until August 8th of 2017?
Yes, sir.
And were you a firefighter?
Yes, sir.
And were you on a medical leave of absence?
I was on medical leave of absence, correct.
And when did that start?
It started in June 6, 2016. I was recommended to take a leave of absence by a battalion chief supervisor by the name of Gary Kakana.
It doesn't matter. That's irrelevant. According to the employer, you were not released by a Chicago Fire Department physician to come back to work. Is that correct?
Correct.
Okay. And to your knowledge, what was that reason?
Sir, he just told me, the doctor from the medical division stated that I was unfit to return back to work. I inquired as to why I was unfit. I requested a second opinion. I was denied that second opinion to return back to work.
But really, all of that isn't really relevant. I'll just tell you. You felt you were able to return to work. Did you have a private doctor, Mr. Alamo?
Yes, I did.
Okay. So your private doctor, did he or she release you to work?
Yes, sir. Twice.
As of what date?
July 14th, 2016, and then again on June 6th, 2017.
We're talking about a year difference. On July 14th of 2016, were you released to work without restriction?
Yes, sir. Yes, sir. By yes.
Is this for a physical medical issue or a psychological or psychiatric issue?
It was the medical leave was due to stress factors. I was going through a divorce and I had a terminally ill mother in the hospital.
Okay. So psychological issues.
Correct.
And were you ever allowed to return to work?
No, sir. I was after I provided the medical release note that the fire department provided to me. I was to give this form over to my treating doctor. I gave this form. He filled it out. I returned it back to medical. He released me to go back to work.
A simple yes or no. So your answer is no.
No.
I don't have any questions here, folks. From what the employers now stated and the claimant was discharged. I don't see any misconduct here. Ms. Gales, are you alleging misconduct?
Yes, because he...
Well, what's the misconduct? What's the misconduct? I missed it. I didn't hear anything.
Well, actually, sir, there was no misconduct, but because of he was released, he was terminated from his job because he was not released by the fire department.
So there's no misconduct?
No, sir.
Okay, so why'd you bring the appeal?
Because the Sedgwick automatically appeals every decision that goes against their company.
Okay, I was just wondering. I thought maybe I'm missing something here, but I hear no misconduct. You've admitted there's no misconduct. Miss DeBell, do you have any questions for your client?
Judge, are we still considering this case under 601?
No, now we're going to do it under a discharge because your client did not agree that he quit, and he felt there was other information. So now it's back to being a discharge.
All right, Judge. Then the only question I'll ask my client is this. Mr. Alamo, did you ever receive any disciplinary infractions of any kind from the fire department?
Is it relevant to this case?
Well, we're now discussing misconduct. Did you receive any disciplinary infractions that related to the reason why the fire department did not release you to return to work?
No, ma'am.
Okay. And did you go to a psychologist to...
Really not relevant, Ms. DeBell, and I don't want to get into his personal stuff.
All right, Judge. Okay.
Okay. Ms. Gales, any questions for Mr. Alamo?
No, but if we could go back to Miss Flores.
For what?
Because Miss Flores was in contact with Mr. Alamo, and before the termination, he had choices that he could have made regarding remaining employed.
What choices were those, ma'am?
Whoa. You're not talking, Mr. Alamo, for one thing. Ms. Gales, why didn't you bring this up when your witness was testifying?
At the time, we were going through the 601B1.
No, we weren't. We were back to Section 602A because Mr. Alamo said, no, that's not the case.
I apologize, sir.
Okay, Ms. Flores, did Mr. Alamo have a choice to remain employed as a firefighter?
Yes, he had options.
Well, what option?
To request a leave of absence.
Well, no. We're talking about he's got to return to work from his own doctor. He wasn't released by yours. How could he return to work? Tell me. return to work. Are you allowing him to return to work? Yes or no?
Well, the Chicago Fire Department physician has to release him to return to work.
So the answer is no. He didn't have choice to remain employed. Was there any circumstance that he could come back to work as a Chicago firefighter?
Only with the release from the CFD medical physician.
Which he didn't have. Correct?
Yes.
Ms.
Correct.
I don't know why we're here, folks. This is absolutely ludicrous. Ms. Scales,
I agree.
any questions for Ms. Flores?
No.
Fine. Ms. DeBell, any questions for Ms. Flores?
No, Judge, I think you've laid it out.
I'll just tell you, folks, this is my decision, point blank. Claimant was discharged for a reason other than misconduct. He gets benefits. The employer is charged. Have a great day.
Thank you, Judge.